Yes, state. Yes.
Yes, this report is between assessors, TST, just is my name. I appear on behalf of the test.
May it please the court, my name is Kelman here with Mr. A. here. I apologize, our colleague, Mr. Distro, is not.
Very well, but we can proceed.
Yes, we can proceed.
Okay. Yes.
I made on my feet, my lord, to motivate an application that we have discussed with the state, and this follows from the rulings of the court yesterday, namely that we today motivate our constitutional issues, and that the intention was that we would meet with the state council to see which issues would be agreed as matters of fact to be a basis for the application that we intend to make as constitutional representation. We have since realized that it would require that we put our factual amendments together, meaning that we assert exactly what it is that we are saying in respect of our constitutional issues and the facts that are preconditions to those amendments. Once we put them on paper, we will send them on the state, and then the state could, in their response, indicate which areas are disputed and which areas are not. And it is only in that context that we may be able to reach an agreement on agreed facts and an agreement on areas that are not agreed. We then indicated to our colleagues that we will make an application for postponement to enable us to put in writing an application for on the constitutional issues, all of them, by starting with the one that relates to the composition of the court. They didn't seem to be in agreement, but I think we'll hear on the same application. So I'm on my feet to make that application for postponement of the matter to enable the defense to put in writing the application related to constitutional issues that we would want to refer to the Constitutional Court. My Lord, we say so as we make this application on the basis that we think that it might be in the interest of the administration of justice for the two accused persons to then make a joint application instead of two separate applications or two separate presentations, which would have to be the case if we are to proceed the way we were proceeding yesterday. So that is one of the reasons why we would do that. I thought I should make reference to first two cases, case authorities that I want to draw attention to case for. The first one is the case of Farai Matsiga and another versus Moses Tondirai Chingwena and 37 others. It is Supreme Court judgment number 106 of 23. And then SC 106 of 23, there I refer to paragraphs 48, 49, and 50 of the judgment of the Honorable Deputy Chief Justice Bwaunza. My Lord, I make reference to those paragraphs because the issue of whether or not an application for referral must be in writing or can be made orally was the subject matter of discussion in the Supreme Court. In that case, the court then did not have to make a determination because the applicants then had to relate. It was opposed. The presentation was that it has to be in writing as a matter of constitution. The debate there ended with the applicants giving in. And so an oral application was then made without putting the application in writing. That became the subject of an appeal ground to the Constitutional Court in the case of Farai Matsiga and another versus Moses Tondirai Chingwena and others, CCs at 9 of 24. And as paragraph 11 of that judgment will show that that was a matter that was subject to appeal. Unfortunately, the Constitutional Court disposed of the matter before it without addressing that issue.
What? Reference.
It ceases at 9 of 24, that's the judgment. And then the paragraph that is relevant is paragraph 11 of the judgment of that court, which summarizes that ground of appeal. It was an application for leave to appeal. And this was one of the grounds. The ground that appears in paragraph 11 is very specific. It actually says that the Supreme Court erred in entertaining an oral application for referral, meaning that all applications for referral ought to be in writing in view of requirements of the rule. So what I am presenting before you is that there is no determination that will be binding on you as to whether this you would allow the postponement for purposes of reducing this application. But our reasons for doing so also arise from the most recent judgment of the court of the Concord in Patricia Dengezi, or people that citation, Patricia Dengezi versus Mnyaradzi Nyamururu. Patricia Dengezi versus Mnyaradzi Nyamururu. This is CCZ 18 of 23. And I refer the court to paragraph 20 of the judgment. In that case, the full court said that the first question they will always consider whenever a referral is made is to determine whether the referral was properly made. And the judgment cited there, if one has to have regard to it, the Constitutional Court is very, very strict about the manner in which the referrals are referred to it. And that is where in the interests of justice, and particularly with a view to the interests of our clients, the accused persons, we would request that we properly put in writing on the record what it is that we are saying, the arguments we are making, the factual basis that we intend to rely on, and serve our colleagues in the shortest possible time. Then they respond, we get to see where we are disagreeing. And should we then, when we come back to the motivation in the shortest possible time, we will know where we need oral evidence and where we don't need it. And the questions will also be very clear in our written submission. We intend to clinically put, we do have the questions. But I know that if I start reading the questions, my little friends would have difficulties in taking them down. And the problems I'm sure in following, we would take days to get this. But this is our preferred process, and we're in the hands of the court. But that's where we are making the application. We had thought that we would require for our side up to Tuesday next week. So Tuesday, the 8th of October, we serve the state with the papers outlining our issues. And if they come back to us within a day or two, then we will be ready for the court before the end of the next week. That is our brief application, my lords. An application to enable, for the postponement of the matter, to enable us to streamline and systematize our applications in the interest of trying to meet the requirements of particularly Rule 24, Sub-Rule 4 of the Constitutional Court rules, and also I think Rule 108, Sub-Rule 4, Sub-Rule 4 of the High Court rules, 108. They require us to be very clear and concise. That would be all.
Thank you. Mr. Treasurer, you confirm that the associate yourself on the submissions?
Indeed, my lord. I confirm that. And I confirm that we get an occasion to interact and we indicated this approach to our learned colleagues from the state.
Thank you. State.
Indeed, my lord, the state and the council for the two accused persons had an occasion to discuss the issue of the constitutional questions that we were raising, but did not seem to converge. But however, it was being proposed that it was in the best interest of the clients to have the application filed in writing. And the state, under the circumstances, is not reporting that application.
We will not be opposed to the request to reduce the application to
Right.
written application.
Up to this time, the state does not know what issues that they are raising, because we did not get into the merits of the state nature of the issues that they are going to raise. I'm sure if it is reduced in writing, then there won't be any issue of keep on prevaricating. It will be certain. That is all I don't know.
Thank you.
I have to record our indebtedness to the approach taken by this.
You have to.
Record our indebtedness to the attitude and approach that was taken.
Very well, thank you. It's in view of the fact of convergence between the state and the accused persons. We need now to set the time frames within which the papers will be filed. Mr. Maduku, you said you'll be able to file the written application by Tuesday. What will the date be? 8th October.
We file and send.
Very well. State, when will you be able to file a response to the application?
If we receive what we will file, I'm sure they will file without February 14th, Monday 14th.
Yes. And then when can we proceed? Registrar? What is the next date available?
15.
How is the 15th of October? State?
Instead of being involved, there's a case for two co-accused persons for what?
Oh, I see. How is the... And how is the following week, Registrar?
Following week.
I hadn't realized that you were addressing the list.
Oh, I see. Looks like the 15th is not available. The 22nd is also not available. 29th? Let's try to is this one, so we can do it on Monday. How about the 29th? State?
If an accident of the court road, whether is it for a day or for what time period is being set aside?
A day should suffice for the purposes of motivating the applications. And
I'm sure if it is the 22nd, I think we can check, but if it's 29th, we will have just as if we got with the contract, that they've made out the set for that week to the following day. I'm sure that
so we can have the matter on the 22nd.
we can have the matter on the even the 22nd.
22nd.
If it's one day,
Yes.
then we can use the other 3 days.
22nd October.
We have to agree to the 22nd.
22nd. Very well then, it will be ordered as follows. The accused persons will submit their application for referral to the Constitutional Court by Tuesday, the 8th of October. By the end of business on that day, they shall file and save that application. The state will file its notice of opposition by Monday, the 14th of October, 2024. The parties will therefore appear before this court on the 22nd of October for argument. Stand up, accused persons. This matter will be postponed to the 22nd of October 2024 at 10 a.m. for continuation. Any other business, please? The court will rise.
Inputs